Welcome back to PBH 275, Injury Prevention and Control. This week's module will cover the role that laws and consumer choices play in injury prevention. We will start by talking about the police powers of the government for the use in public health and also for injury prevention, and the laws that made it possible to enforce this police power that the state has for public health protection. Then we will talk about administrative laws that have to do with injury prevention. Now, some of these laws have been covered or will be covered in other modules in greater detail, so it won't be all of the administrative laws that have to do with injury prevention, but several of them. We'll talk about some of the court cases that established current laws and the current ability for the state and federal and local governments to have police powers for public health and injury prevention purposes. Then we will talk about tort law. This is the type of law that involves civil decisions where it's not a criminal case, and oftentimes the only thing that happens is people will get penalized monetarily. But tort law has an important role to play in injury prevention as well. And then finally, we're going to talk about our consumer choices, the things that we choose to buy and the services that we choose to utilize, and how these choices can either reduce or increase injury risk amongst individuals and also within communities. I will start off this module by defining what I mean when I say public health law. Public health law is the study of the legal powers and duties of the state to protect the health of the people. But there's more to it than that, though. Public health law is also about the limitations on the power of the state to constrain the autonomy, privacy, liberty, and the proprietary or other legally protected interests of individuals for the protection or promotion of community health. This is the underlying tension of public health law. Sometimes, in order to promote the general welfare and the public health of the greatest number of people, you have to constrain the autonomy and the freedom of some individuals. And anytime that's going to happen, there are a lot of other constitutional protections of freedom that sometimes clash with what maybe the public health authorities think needs to happen. And so this is kind of the delicate dance of public health law. So a lot of public health's greatest achievements that have occurred since the beginning of the 20th century, the beginning in the 1900s, have really relied heavily on laws and regulations. Some examples would include, here in the United States, we have very high rates of childhood immunizations for childhood diseases. And one of the reasons that we have such high rates of childhood immunization is because laws and regulations we have that state before your child can be enrolled in a public school or even in a private school that receives federal money, that they have to be vaccinated against some of the common childhood diseases that would tend to spread in a confined environment, such as in a school. And if you do not want your child to be immunized, there has to be a specific medical or religious exemption filed. Otherwise, they can't enroll in school. So that's an example of a public health achievement that's relied heavily on law. Improved motor vehicle safety is another example. Yeah, engineering in general has improved motor vehicle safety a lot, but a lot of those engineering changes didn't happen until they were mandated by a new federal agency. In this case, the National Highway Traffic Safety Administration. I mean, there are now specific regulations for how much energy absorption has to happen in the crumple zones of a vehicle, for example, and how fast a car is allowed to go. A lot of cars have governors on them to prevent them from going too fast. And just a lot of motor vehicle safety has been due to laws. Probably the most clear example of this would be our workplaces are safer now because of one specific law here in the United States. That would be the William Steiger Occupational Safety and Health Act of 1970, which established OSHA, the Occupational Safety and Health Administration. And so now we have a regime of compliance inspections that take place in workplaces, and if workplaces are found to be unacceptably unsafe, if they're if they're failing in their general duty to provide a workplace free of recognized hazards, workplaces can be penalized with monetary fines. They can even be ordered to be shut down through an administrative law judge order if it's found they're endangering too many employees. So yeah, these are all examples of how some of the greatest achievements in the 20th century have relied heavily upon laws. Governments can also sort of, in a way, enforce public health law by what they choose to fund. An example of this would be, there is no law that mandates that all citizens have to be screened for breast cancer or prostate cancer or any other types of diseases. But what the government can do is they can fund programs for screening or for certain types of educational programs, such as nurse home health visits, and they can tie it to other types of funding. So the federal government, for example, could say to state governments, or the state government could say to local governments that we're going to give you some funding, maybe a block grant for certain programs, and things are going to help your citizens. But this is tied to you have to do these screening efforts or these education programs. If you don't do them, you will not receive this additional money that can be used for other things that the lower level of government might want to do. So in this case, it's not a law per se, but it's a expectation of public health and injury prevention performance through the denial of money if things are not done. And of course, in some cases, education programs can actually be directly mandated by law. For example, if you're a parent or caregiver and you engage in some risky or illicit behaviors, you might be mandated by the courts to do some certain education programs before you can regain custody of a child. So again, funding is another way that the government can sort of enforce public health law, even if it's not official formal law. So when we talk about actual public health laws, real laws that come from governments and that are enforced by the police power of the government, there's a few different varieties of these. The governments, for example, can enact statutory requirements. These tell us what we can and cannot do, just that or what we're expected to do very explicitly. Like mandatory school immunizations touched on earlier. You cannot enroll a child in a public school or a private school funded by federal money unless all the school immunization requirements are met first, or you present a valid medical and religious exemption reason for not having the immunizations. Seatbelt use laws. I mean, here in the U.S. in every state now, you don't really have an option not to wear a seatbelt when you're in a vehicle. I mean, you can do it, but if a police person notices you are not wearing a seatbelt and you get pulled over, you can get a ticket for that and a small monetary fine. Graduated driver's licenses exist in a lot of states, and that means that when you first get your license, you don't necessarily have all the freedom and all the autonomy that the license grants to a more experienced driver. There are limitations on how many people you can have in a car, what hours of the day you can drive, or if you have to have an adult present. And those eventually get released as you get more experience, but to start off, you have some early limitations on your driver's license. One important statutory requirement you might not have thought of, but it's really helped us a lot, especially in the realm of injury prevention, is mandatory external cause of injury coding. These are the ICD-10 codes that exist in the WSCAR system. And these are important because they standardize, for example, injury data in a way that maybe it had not before, because this data comes from emergency departments and health departments all across the US. And if there was no standardization, there could be all sorts of different ways that people code things, and it would be hard to compare rates between regions. So this helps us standardize and get standardized data across the US and get a better idea of if we're having any injury or other public health issue hotspots in particular regions where we need to focus some additional public health resources. And this has also helped internationally because the ICD-10 codes were actually developed by the World Health Organization with the intention that every nation would eventually adopt them. And so we can actually compare, for example, fire and burn injury rates across nations and find out where there are greater problems or motor vehicle collision fatalities, or just lots of different things where ICD-10 codes that are statutory requirements for all these downstream entities that track data has really helped a lot. Zoning is another example of a statutory requirement that has some public health and injury prevention impacts. I mean, the biggest example of this in the US would be in a lot of regions there are zoning requirements that residential areas are not permitted to have certain more noxious, possibly less safe land uses within their midst. Like you can't have a polluting factory or a landfill or a strip club or other things within certain residential zoning areas in many jurisdictions here in the US. There are some states and cities that don't have good zoning laws, but zoning laws really can help with quality of life and safety of community issues. Another very large category of public health law is simply prohibitions. These are laws that just flat out tell us you are not permitted to do this. One example of that would be drunk driving laws. You are in every state in the union, you are not permitted to operate a motor vehicle if your blood alcohol content is above 0.08% or above 0.05% in Utah. As the COVID-19 pandemic reminded a lot of people, the government has fairly extensive powers for isolation and quarantine, where if a person is known or suspected to be a vector of a highly infectious disease, they can actually be forced to be isolated or locked down or quarantined and separated from the rest of the population until such time as it's deemed they're no longer a threat to spread an infectious disease. We don't have particularly robust gun laws in this country, but we do have some, and one of the examples of prohibition through gun laws is that if you have been convicted of a felony, you pretty much lose your ability to ever own a firearm from that point on, unless several years later, you can apply to have this right restored, but it's kind of a long and difficult process. And of course, there are certain substances, particularly controlled substances and illegal drugs, that you are not allowed to possess, and if you are, you are likely to be charged with a crime, and at the very least, those substances can be seized by your governmental authorities, and you will not receive any restitution for their cash value. And finally, public health law. The other big category of it is broad regulatory programs, where an entire new agency is created with administrative powers. For example, the Federal Consumer Product Safety Act is the reason we have the agency we now call the Consumer Product Safety Commission. And the Consumer Product Safety Commission is the agency that ensures that any product that's released into in the United States is safe, is designed to do the thing that it says it's going to do. So that no more, for example, medical products that don't do that make outlandish claims and don't deliver on their claims generally don't happen anymore. Unsafe toys are kind of a thing of the past now. Unsafe playground equipment. Another example of this would be the Occupational Safety and Health Act, which is the founding regulation that created the Occupational Safety and Health Administration mentioned earlier. When we talk specifically about the injury prevention laws within public health law, just like the other types of public health law, they can either require you to do some things or prohibit you from doing some things. And injury prevention laws can be directed at individual behavior, again, that's people, at products, this would be things or objects, or at environmental conditions, the places where we exist, where we work, play, sleep, things like that. Some example of injury prevention laws aimed at people would be, of course, drunk driving laws, speed limits, laws against various types of assault. Laws that are aimed toward things would be motor vehicle safety standards that have to do with the car or the road. Like there's laws now that if you're going to receive highway funds, your roads have to be designed in such a way that curves are safe and that roadside obstructions are minimized. And of course, we talked about safety standards before, about for crumple zones, for how much resistance a seatbelt should have, how quickly an airbag should deploy, things like that. The entire Consumer Product Safety Commission and all their laws and regulations they have to ensure that toys, consumer products, consumer services are all safe, and the gun restrictions like we talked about before. And then some of them are directed at environmental conditions or places. While a lot of states have laws about open carry or concealed carry, the one place you absolutely cannot carry a gun unless you're a marshal or a sworn law enforcement officer is an airport. It's like, don't even try it. That's a pretty uniform prohibition that you cannot do that. A lot of municipal swimming pools have, and also private swimming pools that exist in towns have laws about fencing, about ensuring that you are at least trying to limit access to it so that if somebody does jump over the fence and gets and drowns or has some kind of incident, there's at least some liability protection. Another example that you might not think of is that if you've ever been driving on a highway and either you get drowsy or you try to suddenly veer to avoid a car or wildlife or something like that, and you hit one of those road signs along the side of the road, those are all designed to break away because that's a requirement that's in place for all highway signs now, that they kind of break away when they're hit by a vehicle. They used to not break away, and they would cause a lot of impalement and often decapitation and really gruesome injuries to people inside cars. So that's an example of injury prevention laws directed at environmental conditions. This table illustrates some of the milestones in injury prevention law and regulation here in the United States. I'm not going to go over all of them, but I'll just go over a few highlights. 1966 is when the National Highway Safety Bureau was founded. That was shortly after Ralph Nader published his book Unsafe at Any Speed about the Chevrolet Corvair, but also just in general about the uh, the things that automakers were not doing to make a safer car. Of course, it was later renamed the National Highway Traffic Safety Administration and put under the U.S. Department of Transportation. 1970 was the William Steiger Occupational Safety and Health Act we've talked about already. In 1972, the Consumer Product Safety Act that established the Consumer Product Safety Commission was founded, along with many other acts such as the Flammable Fabrics Act, the Hazardous Substance Act, and the Poison Prevention Packaging Act. In 1974 was when CAPTA, the Child Abuse and Prevention and Treatment Act, was passed by Congress. And by 1985, all states had child passenger safety laws requiring, infant seats or booster seats, just different types of safety equipment for children who are smaller than adults and maybe they can't use the traditional seat belts that adults can yet. And the ways that those were enacted by all the states was because federal highway funding was tied to these states having these laws. And then in 1993, Congress passed what we call the Brady Bill, or the Handgun Violence Prevention Act, which gave us the now familiar background checks that occur before a sale of a gun or other firearm at a federally licensed firearms dealer. So again, these are just some examples of injury prevention laws and regulations here in the United States that have made a really big difference. For those of you who are public health majors, this will probably just kind of be a refresher or a reminder, but the government has police powers to promote health, safety, and the general welfare. And in promoting health, safety, and the general welfare, the government actually has, amongst its police powers, the right to take away freedoms from individuals in certain limited circumstances when the actions of those individuals could impact the health, safety, and the general welfare of the larger population. Now, these police powers of the government, there's a few different layers of them. Probably the one that's the least controversial is that these police powers can prevent you from harming others. And these police powers exist in governments all over the world. You can't assault or murder or do other things to other people. That's there's no real controversy with that. What's often a little bit more controversial, but mostly accepted, is that governments have the ability to promote the common good. And they can do this through things such as quarantines, as we've seen during many infectious disease outbreaks, including with COVID-19. Governments also, this is a power that's reserved to the federal government and not given to state governments, is the power of interstate commerce. That power means that we are a republic of 50 state governments, but state governments are not allowed to undercut each other and do things such as, block a neighboring state from bringing in produce or conducting business for citizens in another state. Interstate commerce is a power that's reserved for the federal government to regulate that. Governments at all levels have taxing and spending powers, and also withholding powers. And again, people might not like the idea of having their individual freedom usurped for in a quarantine situation. People don't necessarily like paying taxes, but for the most part, people understand that that's a legitimate use of government police powers. By far the most controversial of the police powers of the state are any time that regulations or laws are passed to prevent you from harming yourself. This was the argument that was made for many years against seatbelt laws. The idea was that why should I be made to wear a seatbelt by my government? If I get into a crash, I'm only going to harm myself, which is not entirely true. I mean, the society in general also gets harmed by people who get into collisions and they die or they are severely injured. But that was the thinking for many years, and that's what was a lot of the pushback against these types of laws. Before we knew what we know now about the dangers of secondhand smoke, this was also one of the reasons why citizens often push back against anti-smoking laws about not being allowed to smoke in certain places. Their thought was, why do you care? I'm only hurting myself. So anyways, anytime you have a law that prevents people from, where the perception is you're preventing people from only harming themselves, by far that's the most controversial use of police powers of the government for public health and injury prevention. So the federal government generally takes the role in what we call interstate issues, where you have, say, a public health or injury prevention issue that affects multiple states at once. But in general, states have the primary role in public health rather than the federal government. The United States is a republic of 50 state governments, with like a federal government that provides some overseeing power, and also some of the establishing regulations for injury prevention come from the federal level. But they're mostly enforced at the state level. So what happens is we have a federal agency, such as the Occupational Safety and Health Administration, or the Environmental Protection Agency, or the Consumer Product Safety Commission. But then there will, in every state, well, in many states, rather than having the federal government enforce these laws, they will have a state-level equivalent agency to that federal agency that actually enforces that laws. And this state-level equivalent agency must be at least as effective as the federal agency would be. Otherwise, that state-level government equivalent agency can lose their accreditation temporarily or permanently. When I was working in North Carolina for the state OSHA program, when I was hired on, this was a time when the state OSHA program was coming out of a period where they lost their ability to perform inspections in North Carolina because of well, it was because of the aftermath of the Imperial Foods fire disaster that I talked about in the occupational injuries lecture. But yeah, the federal government took over all OSHA enforcement in the state of North Carolina until such time as the North Carolina state program could get back on its feet, could train its people, and bring its staffing levels up to a high enough level to ensure that the state could do as good of a job or better than the federal government could do. And then they regained their accreditation, and they've had it ever since then. In a practical sense, what this means is that here in the state of Nevada, for example, we have a Nevada Division of Environmental Protection that enforces the U.S. EPA laws here in the state. So if you're at any kind of workplace or facility and an EPA inspector comes on site, more than likely it's going to be a Nevada DEP employee that you're dealing with rather than a U.S. EPA employee, unless you're on federal property, such as the Nevada National Security Site. The federal government tends to keep jurisdiction over federal agencies. The same with if you're in a Nevada workplace that's not on federal property. It's usually the Nevada Division of Industrial Relations inspector that will come rather than a U.S. OSHA inspector. And it's the same with Health and Human Services. Nevada has a Department of Health and Human Services that enforces most of the regulations at the state level. So again, in the U.S., many public health and injury prevention powers are given to state governments under the authority of the federal government. Are there lower level governments that are given public health powers? Well, it depends on the type of rules that are established within a particular state. There are some states whose attitude and jurisdiction of local governments comes from what's called Dillon's Rule, which comes from the interpretations of U.S. Circuit Court Judge John Forrest Dillon back in 1868. For states that obey Dillon's Rule, what this means is that the powers of local, meaning city and county governments, are very limited, to administer public health and injury prevention laws. And if they do administer them, they cannot differ from the state laws. A clear example of this would be one limited way that Nevada is a Dillon's Rule state is that we have a specific law that states that no local government, city and county government meaning, is allowed to make firearms restrictions that are more strict than the state rule. And again, if you want to know where Dillon's Rule comes from, the quote from Judge Dillon is up here, that municipal corporations owe their origin to and derive their powers and rights wholly from the state legislature, and that state legislatures breathe into these smaller governments the breath of life, without which they cannot exist. So yeah, Nevada is for the most part not a Dillon's Rule governing state, except for the one limitation, the one exception of firearms laws. Nevada is instead, as of 2015, what's called a home rule state. And in a home rule state, the state will generally give local governments authorization to carry out certain functions without legislative authority for each activity. I mean, unless the local city or county governments are doing something that the state legislature considers to be outlandish or well beyond the bounds of what a local level government should be doing, for the most part, in a home rule state, the state government will be like, yeah, that's fine. You can enforce that at your local level. And again, as of July 2015, Nevada is officially a home rule state, except for that one small carve out that has to do with firearm regulations. Many of the public health and injury prevention laws we have here in the United States don't actually directly come from legislators. They come from administrative agencies, and therefore they're called administrative laws. Some examples of this would be, of course, as I've alluded to many times in here, the rules for workplace safety, they generally come from administrative agencies, either the Occupational Safety and Health Administration or their state level equivalent. They don't come directly from Congress because that would create a logistical nightmare if every time you wanted to change a workplace safety law, it had to, it actually had to be introduced in one house of Congress, passed by both houses of Congress, and then signed by the president, even if he just wanted to make a very small change. So for the most part, what the higher level governments will do is they will establish an administrative agency that actually makes the day-to-day laws and regulations. And there will be founding laws that establish these administrative agencies that come from the legislators. And these founding laws will define the scope. I mean, the William Steiger Occupational Safety and Health Act sort of spells out exactly what the administrative agency OSHA is supposed to do, just like the Consumer Product Safety Act spells out what the Consumer Product Safety Commission is supposed to do. Now, administrative laws, even though they don't come directly from legislators, are just as binding as traditional legislation. However, there is one way that administrative laws might be perceived as a little bit weaker than traditional legislation, and that would be that oftentimes administrative laws will get challenged in court on the basis of the legislators that established this agency never intended for this agency to regulate this particular thing. This happened many years ago with the Occupational Safety and Health Administration when some state-level OSHA offices started trying to promulgate and enforce workplace ergonomic standards. And these laws were developed in a couple states, one of them being California. North Carolina attempted to establish them too. And they were struck down in courts because the belief was that the founding legislation, introduced back in 1970, that it was never intended that this particular type of workplace injury issue was intended to be addressed by this piece of legislation. So again, challenges in court based on legislative intent are kind of unique to administrative laws. I mean, with traditional legislation, it's a little easier to find out what the legislators intended because it'll be in the law itself or in the preamble to the laws. I hope this graphic can sort of simplify the division of powers that often occurs here in the United States, where the federal government will grant powers with conditions to state, tribal, and territorial governments, where federal administrative agencies established by federal laws will grant powers with conditions to state administrative agencies, provided that those state administrative agencies are just as, or at least as effective as a federal agency would be if they were enforcing the, the laws and regulations in that state. State governments can grant powers with conditions to city, county, and other local governments. A little bit more powers are granted in home rule states versus Dillon's rule states, but again, there are often conditions to that power. And federal and state legislatures can grant powers with conditions to federal and state administrative agencies. That way, the legislatures don't have to be burdened with, creating every single minute law and change to law that needs to occur for the daily operation of some of these administrative agencies. The administrative agencies are allowed to do that, provided that they don't exceed what the legislature believes is their right to do so, or if a citizen challenges this in court, if it's upheld. Injury prevention laws are similar to a lot of other public health laws in that they have been enacted over decades or centuries. I mean, some of them are hundreds of years old, some of them are only a couple of decades old. They tend to be a patchwork of laws that are unsystematic and scattered throughout numerous statutes and regulations at the state and local levels. And the sad truth about our injury prevention laws is that they're often reactive in nature. Many injury prevention laws, for being quite honest, are written in blood. In other words, they only occur because a high-profile or mass casualty event occurs, and following that event, it becomes obvious that there needs to be a law or regulation to maybe prevent such a bad thing from happening again. It would be great if we were more proactive in our laws, but that's just not been the history of the way things have gone here in the United States, and honestly in many other countries as well. Almost every injury prevention law that's ever been promulgated in the United States has been challenged in court by somebody. Injury prevention laws are not always met with universal approval, especially when they limit individual autonomy or when they can possibly cut into corporate profits. The person whose freedom is being limited, or the company whose products are going to be more expensive if this law comes into being, they will often push back. There are a few different ways that the validity of an injury prevention law can be challenged. One would be just to dispute the law's validity in general. There's often in court it will be alleged that the government lacks constitutional authority to do this thing that this law proposes that they do. And in that case, what you have is it depends on whether the court takes a sort of a wider or a narrower view of the Constitution. We have a Constitution for our United States government. Every state has their own constitution as well. And the narrow interpretation that a lot of courts take is that if it's not specifically written in the Constitution that this government at this level has the power to do this, then they can't do it. Whereas a more broad definition of powers under the Constitution is that, the government, this is a reasonable use of government power, even if it's not specifically written in the Constitution as one of those things. Another challenge that often happens toward validity of a law is that there will be the argument that there's a greater legal principle that takes precedence, that if you pass this one law, that there might even be a compelling public health reason for it, but there's another protection we have under the Constitution that is impinged upon by this law. An example of this would be the Fourth Amendment to the federal U.S. Constitution protects citizens from unreasonable search and seizure. Well, over the past several years, many states have started implementing DUI checkpoints where the Highway Patrol will set up a checkpoint and just randomly put on certain roads, and every driver that goes by will have to stop at the checkpoint and be sort of screened for signs of impairment while they're driving. And if they're suspected of being slightly impaired, you might be asked to come out of your car and take a breathalyzer, or maybe do the walk to demonstrate, basic field sobriety. Well, these laws were challenged under the with the Fourth Amendment argument of like these being an unreasonable search and seizure. And it went all the way to the U.S. Supreme Court. Ultimately, the U.S. Supreme Court did side with the states that were enacting these DUI checkpoint laws, and the actual quote from the Supreme Court decision was that the needs of the state to prevent drunk driving accidents outweighed the minimal intrusion on sober drivers who just happened to get caught up in the DUI dragnet. Thus, the justices argued, DUI checkpoints did not constitute an unreasonable search and seizure. So in this case, the injury prevention law held, but these are the kind of challenges that are often brought up with injury prevention laws. And as I alluded to before, in the case of administrative laws from administrative agencies granted powers by legislatures, these laws can often be challenged based on legislative intent. While some courts are known to take more liberal views of injury prevention laws and some to maybe take more conservative views, in general, the trajectory here in the United States for the last several decades has been that courts tend to uphold the validity of injury prevention laws, but there are some notable exceptions. As I talked about before, ergonomics laws from federal OSHA and from a few state OSHA agencies have not been upheld by courts. They were struck down because it was believed that that was going beyond the scope of what OSHA was supposed to do in terms of preventing workplace injuries and illnesses. And many firearm injury prevention laws at various government levels have been struck down because courts tend to take a very very broad view of the Second Amendment to the U.S. Constitution, that it conveys an individual right to own firearms with almost unrestricted access. There are a few courts that tend to interpret the Second Amendment as being more of like a much more narrow right to have arms in service of a state militia, such as the National Guard. But for the most part, most courts tend to take a very broad view of the Second Amendment. So that's why firearm injury prevention laws often get struck down at courts. If you're going to propose an injury prevention law, you can expect there to be legal delays and roadblocks. That's going to be an inevitable part of injury prevention and really of public health in general. The police power of the state to enact any laws and restrictions needed to protect public health has really gone all the way back to 1905, was the first court case that really established this as a legitimate use of power in government. The Jacobson versus Massachusetts case established the authority of the state to enact quarantine laws and health laws of every description. As far as the case itself, there was a man named Hennig Jacobson who had received the smallpox vaccination when he was a very young child, and he had a fairly adverse reaction to that vaccination. So then later on in 1905, when he was an adult and was required once again to get a smallpox vaccination as part of a campaign to eradicate smallpox and stop an outbreak that was occurring on the east coast of the United States, he refused to get the vaccination and took it to court, saying that his rights were being violated under the state and the United States Constitution. Well, and it went all the way up to the Supreme Court, and in the Jacobson versus Massachusetts decision, the Supreme Court disagreed. The Supreme Court agreed with the idea that this was a legitimate use of the police power to protect public health, and from the decision they said, there are manifold restraints to which each person is necessarily subject for the common good. And many other public health and injury prevention laws in the ensuing decades have kind of gone back to the Jacobson versus Massachusetts decision as sort of their justification for this. We have the right to do this. It's for the common good or the greater good. So it's one thing to use those police powers to protect public health when we're talking about a deadly infectious disease such as smallpox, where one person who's infectious and who's allowed to run uncontrolled through a population can cause just a devastating epidemic and maybe even a pandemic. As I talked about before, though, the most controversial applications of public health and injury prevention law tend to be when we have laws that upon first glance, the intention of them is strictly to protect a person from their own actions, where they seemingly don't necessarily affect others. And this was the case with back in 1987 when a man named John Hartog sued in the court system of Iowa because he had received a click it or ticket citation when he'd been pulled over at some point and was found not to be wearing a seatbelt, and so he was given a monetary citation. And so Hartog decided to sue. He took this to court, and it eventually reached the Iowa Supreme Court. His argument was that Iowa's mandatory seatbelt laws protect the individual from his own foolishness, but they don't really have any relation to public health or the greater general welfare. The Iowa Supreme Court did not agree with this. They actually pointed out that seatbelt use enhances a driver's ability to control the vehicle, thus avoiding injuries to others. In this case, the Iowa Supreme Court was sort of picking up on some of the arguments that many public health practitioners have been making, that seatbelts protect more than just the individual person wearing the seatbelt. And in fact, the interpretation of this decision and subsequent decisions has been that you can pass a law within the police power of the state to protect the public from financial loss, not just from infectious disease or from other things like that. So in this case, if a person, for example, is in an automobile collision and they're not wearing a safety belt, there can be a lot of additional costs incurred that might not have been incurred if the person was wearing a safety belt. I mean, extra highway cleanup and medical costs, and plus if a person survives a collision and they're unable to work, or they have a partial or permanent disability, I mean, those unemployment and potential disability costs, the whole of society pays for those. So the argument was made and affirmed in the State versus Hartog that yeah, you can make laws like this where even though on their face they appear to only protect the person from their own individual actions, if there can be a sort of a greater public health argument for it. Up to this point in this module, the kind of laws I've been talking about have been on the criminal side of the law, where if you're found to be violating the laws, you can be subjected to felonies, misdemeanors, violations. You can possibly lose your freedom and become imprisoned if you violate some of the criminal laws to a degree where it's found that the remedy would be incarceration. But there's another form of law in the United States, and that's civil law, sometimes known as tort law. And in the case of tort law, we're talking about where civil wrongs that are recognized by the court system as grounds for a lawsuit. In this case, the person that has a lawsuit filed against them, they're not going to go to jail if they're found to be responsible for the injuries, but they might have to pay out a substantial sum of money. In the case of tort law, we're talking about how there's an injury or harm as the basis for a claim by the injured party against the party they believe to be responsible for their injuries. The primary aim of tort law is to provide relief, for the damages that have been incurred, and this is strictly monetary relief in this case, but also to deter other people from committing the same harms, because a lot of times big tort lawsuits with big payouts, they get a lot of press attention, and you find out that, oh, I could be held civilly liable for creating this type of injurious condition that injures somebody. It could cost thousands or hundreds of thousands or millions of dollars. And in fact, when we talk about tort law, there's really there's two kinds of damages that are often awarded by the court system if you successfully file a tort law. One would be compensatory damages. That's the ones that provide relief for the damages that you've incurred. The other one is punitive damages, which I'm going to talk about a little bit more in an upcoming slide. Punitive damages are where we really get to the deterrence, where it puts a big warning out to everybody, like, don't let this happen. Be responsible for whatever it is that might have caused the injury to the injured party. Don't let this happen. And so tort law can be used to fill in gaps in injury prevention law, because as we talked about before, injury prevention laws are kind of patchwork. They come from a lot of different agencies and jurisdictions, and sometimes there's not a law that exists on the criminal law side of things, so you have no recompense but to file a tort or civil lawsuit. And these happen a lot for cases where a negligent thing happens. For example, if a company manufactures a product and one of the products they sell is defective in some way that causes an injury, that would be a common grounds for a tort lawsuit. Or if you're riding in a car with somebody and they drive recklessly, and they're in a collision in which you get injured, you can sue that person for the injuries. And if you know somebody that has a dog and that dog breaks loose sometime and bites you, it's the same thing. It's like nobody, for the most part, people don't go to jail for things like that because it's not really covered under criminal law. But you can definitely be held liable in a tort lawsuit, in a civil lawsuit, for those types of injuries. Here in the United States, there are some limitations that are put on tort law, limitations on the compensatory and punitive damages that can be collected as a result of a civil suit, alleging such injuries that need to be compensated. One of the biggest limitations of tort law is that it, for the most part, does not apply to on-the-job injuries. If you're working at a job that has workers' compensation insurance, which almost every employer in the United States has workers' compensation insurance, you will normally be, if you get injured, you will normally be compensated through the workers' compensation system. And it's sort of a fixed, predictable, no-fault system where nobody has to go to court. It's just the injury happened, it happened on a job, and so a fixed, predictable payment based on the percentage of disability, the part that was injured, or how much time you have to miss from work. It's a it's a system designed to be easier for both workers and employers because it's predictable, it's fixed. It doesn't rely on one side having better lawyers than the other. There is one big exception to this, to workers' compensation being the sole remedy for on-the-job injuries. If you can demonstrate that your employer committed gross negligence that led to your injury, in other words, just a lack of care that demonstrates reckless disregard for the safety or lives of others, then you can pursue a tort lawsuit against your employer. Now, the burden of proof is very high. I mean, normal absent-mindedness or just sort of casual, careless behavior in a work environment generally is not going to rise to the level where the courts would say that gross negligence has occurred and you have standing to sue your employer. So it's a high burden of proof, but under situations of gross negligence, you can sue an employer and possibly collect compensatory and punitive damages. There are also limits on punitive damages here in the U.S., those damages that are assessed as punishment and deterrent for such conduct in the future. And the establishment of limits on punitive damages goes back to 1996 in the case of BMW versus Gore. Now, this case had absolutely nothing to do with injury prevention. It really was a case about a person receiving a product, in this case, an automobile, from Bavarian Motor Works, or BMW, the defendant. And they felt that Gore, the plaintiff, felt that the product was defective, was not as good as advertised, and they pursued a lawsuit. And a lower court ruled in favor of Gore, and Gore was given a punitive damage settlement that, if you were to look back at the case, you would probably think, yeah, it seemed a little unreasonable, a little outsized based on the harm that was alleged in the lawsuit. And in fact, BMW, they appealed this case all the way up to the U.S. Supreme Court, and the U.S. Supreme Court did throw out the punitive damages because they were deemed to be grossly excessive punitive damages that violated the due process clause of the 14th Amendment to the U.S. Constitution. That's the clause that says that any kinds of punishment cannot be unreasonable, arbitrary, and capricious. So that's the standard that exists now in the U.S. If a lower court awards compensatory and especially punitive damages in a tort lawsuit, and the defendant wants to appeal it, the test that will often be applied is, are these punitive damages reasonable, and do they pass the test of not being arbitrary or capricious? There is one other group that has been given special protections from tort lawsuits by United States. The United States Congress has actually designed a law to protect them from these torts, and that's gun manufacturers and dealers. Back in 2005, the U.S. Congress passed the Protection of Lawful Commerce in Arms Act. Both houses passed it. It was signed by the president. What this law did was granted broad immunity to gun manufacturers and dealers from being sued in the event for the harms that might result from their product. Basically, when their products were used in the commission of a crime. This law prohibits qualified civil liability actions, which are defined as civil or administrative proceedings which result from the criminal or lawful misuse of firearms or ammunition. So this law essentially made it that, except for very unusual circumstances, manufacturers and sellers of guns and ammunition, for the most part, they cannot be sued. The National Rifle Association, which not only was pushed for this law, but some of their lobbyists actually helped write this law and make sure that it got before some Congress people. They called this the most significant piece of pro-gun legislation in 20 years. So now, in summary, for the first part of this module, the role of law in injury prevention, just want to remind you that law is one way that we deal with injury, and it's been consistently upheld by courts in the United States, with there's a few exceptions here and there where injury prevention laws have been overturned or reversed, but for the most part, they've been upheld by courts. Many important public health achievements, particularly in the 20th century, stemmed from legislation and then also from laws that came from administrative agencies that were established by legislation. Injury prevention laws are not always met with approval. I mean, they can restrict and limit individual freedoms, they can cut into corporate profits, and there's other reasons why they're often not particularly popular. And the other sad truth about injury prevention laws and regulations, especially at the administrative agency level, is that these protections can be undone when administrations change. A lot of times when a new president comes into power or a new governor, one of the first things they will do is they will look at some laws that are not particularly popular with some of their constituents and decide to repeal those laws or introduce new laws that undo the previous laws. So they're always a little bit susceptible to political pressure. Tort law or civil law can fill in some of the gaps that exist within our, injury prevention criminal law structure. But as I've just talked about in the last few slides, there are some limits to tort law as well. Now let's shift our attention to the other major subject of this week's module, the role that consumer choices can play in injury prevention. I will start by addressing the question that many of you might have when you first saw the topic of this week's module, or maybe first saw this on the syllabus. I'm sure more than a few of you thought to yourselves, what does consumer choices have to do with injury prevention? Well, I hope by the end of this module you can understand this a little bit better, but consider this first. Every product that we use and consume is manufactured, grown, processed, packaged, and delivered by workers. And these workers and their workplaces, they're not just in the US, they could be all over the world. But what's true is those workplaces are embedded within communities. And sometimes those workplaces dominate those communities. And not only that, those communities are embedded within ecosystems. And sometimes the workplaces in those communities also dominate the ecosystems. When you watch the We Buy Who Pays film this week, this will be a vivid example to you of how a couple of key workplaces within a community can completely dominate the employment and other livability characteristics of the neighborhood, and can also really damage and deplete the ecosystem in a way that harms people beyond just the people that work at the workplace. The entire community can be injured. We use the term supply chains a lot, and I'll talk more about supply chains later on, but what's important to know about supply chains is that we have more information now than we ever have in human history about supply chains. They can be more traceable and more knowable than ever before. Any product that you want to purchase, whether it's an automobile, a shirt, a coffee maker, anything like that, you can do a little bit of research and find out where it comes from, what are the labor practices, what are the ecological resources needed for that product. I mean, this information, it can be good to know, it can also be bad to know, and it's something that once you do know it, sometimes you can't unknow it. Now, every purchase that we make can be thought of as a vote. If we buy a product, we're essentially endorsing whatever practices brought that product to us. So whatever labor practices, whatever ecological practices, and whatever kind of ecological resource depletion might have occurred, we're essentially voting for all of those things. And I don't say that to make anyone feel guilty. As we're going to talk about in the rest of this module, we cannot look into every single consumer choice we make. Nobody's got the time to do that or the energy to do that. But I hope by the end of this module you might realize that it's important for maybe a couple of key products that you value a lot in your life, that maybe it's good to do some traceability studies of your own, try to figure out who can provide that product to you in a way that most aligns with your values and your ethics. In order to get where I want us to go in the rest of this module, I need to talk about some economic realities that are not necessarily pleasant to think about. Many of the products and services that we buy come from publicly traded companies. These are companies that have shareholders, where people buy stocks to sort of own a small share of the company. And publicly traded companies, they might have mission statements and value statements, and that's fine, but ultimately, the true mission of almost any publicly traded company, their primary goal is to return value to their shareholders every quarter. When those quarterly earnings reports come out, if the shareholders are happy, that's good. If they're not happy, they might be persuaded to sell a stock, and that's a sign that maybe that's kind of a signal to other investors that this is not a particularly good company to invest in. So that's kind of how that works. So how do you return value to shareholders every quarter and sort of keep growing these things? Well, there's a few different ways. If you're a publicly traded company, you can keep your shareholders happy. One would be to raise prices. Now, that's not particularly popular with consumers of your product, and in fact, that might cause your consumers to switch to a different product that's maybe not publicly traded or that's offered at a lower price for various other reasons that we'll talk about shortly. Another way you can return value to shareholders every quarter is by continuous growth. Keep selling more. And that's a fine goal, I suppose, but a lot of products and services, there's only so big that the share of the market can get. I mean, there might only be so many people that are interested in the product or service, or there might be another company that dominates that particular sector, and it's hard to sort of carve your own niche out of that. So selling more is not always feasible either. So that brings us to the third way that a lot of publicly traded companies try to return value to shareholders, and that's by reducing per unit operating costs for whatever product or service that is being manufactured and sold, reducing the costs, how much it costs to produce this. This is often done by outsourcing production to other countries. Maybe a product that used to be manufactured in the US with relatively high labor costs because of salary and insurance expectations. Instead, you can move that overseas to a place where you can get away with paying a lot less for labor. Or hiring workers willing to work for lower wages. This happens a lot here in the US with undocumented workers, where you hire people who are in a more vulnerable state, who maybe are not as likely to raise concerns about their working conditions or their pay because they're undocumented and they don't want to bring attention to that. So that's another way that you can reduce per unit operating costs. It's not at all an ethical way, but that's the way it's sometimes done. Or sometimes speeding up a process. This happens a lot in places such as poultry processing plants, where they will subtly speed up the line so that every worker has to work a little bit harder every hour, process several more chickens in order to you're not bringing in more workers, you're just making every worker work a little bit harder. And anytime you do this, you increase the risk of injury, and there's just no way around that. Really, everything that is done to reduce operating costs, whether it's outsourcing, hiring undocumented workers, or speeding up processes, all of them often translate to more dangerous working conditions. They certainly lead to disempowered employees and other conditions which can increase community injury risk. And they also lead to injustices. Anytime that vulnerable workers and the communities they live in are asked to bear a risk that we are not willing to bear ourselves, an injustice results. I put "we" in quotation marks there on purpose because who the "we" is will will vary depending on circumstances, but we just we have to be aware of what our consumer choices, what they are doing in the communities where the product and service is being created. There are some business models for provision of services and especially products that are just by their very nature exploitative and injurious. And I wanted you to watch the We Buy Who Pays film because this is a very vivid example of what happens in the garment industry. And the film is a couple of decades old now, but the practices that you see in the film still exist, and still you can still find them in southern India and other places such as Bangladesh and places like Vietnam as well. Just where you have an industry that comes in and just kind of dominates a community and dominates the ecosystems. In the case of We Buy You Pays, we're talking about finished garments and shoes that are sold in Europe and North America, whereas the raw materials, such as the cottons and the dyes that put the cottons in different colors, and the various bits of shoes and the assembly labor all occur in various regions of southern India. Now, in these regions of India where this occurs, there are laws against mandatory overtime and against child labor, but there's virtually no enforcement of these laws. So, in a sense, mandatory overtime and child labor are endorsed by the actual on-the-ground operations of these facilities. These manufacturing facilities in these regions of southern India generate a lot of externalities. They generate dirty water, they generate polluted land, they cause mental health issues for people who work there and also for people who don't. And these externalities are all absorbed by the local community. The movie talked to a coconut farmer in southern India who he could not grow coconuts productively anymore because the land had gotten so poisoned by some of the pollution put out by a dyeing plant. And I wanted you to watch this film because it really talks a lot about this sort of Western-centric view that people tend to have about the developing world, that people do need jobs and opportunities and a chance to grow their economies. But a lot of times the jobs that are brought to these places bring a lot of misery with them as well. And that's a difficult balance that's often struck. I mean, when people argue against some of these exploitative businesses like the ones you saw in the film here, the counter argument is always that what these are bringing jobs, and if these dye and cotton factories were not here, these people wouldn't have jobs. And isn't it better for them to have jobs? Uh, I hope after watching the film and thinking about it, you might see that in some cases the answer might be no. Perhaps the community and the people who are going to work at this place, and certainly the ecosystem around the place, would actually be better off if some of these things had never come in the first place. The only reason these opportunities came was because a enterprising company, usually based in the U.S. or Europe, saw it as a way to reduce per unit operating costs and make the shareholders happy. I mean, to pretend that you're doing a favor to people by bringing them jobs when it's these kind of jobs is really disingenuous and unjust, in my opinion. And of course, I think it should go without saying that very little money from the purchase price of the finished garments or shoes actually comes back to the workers that are producing them and to the communities that are being negatively impacted by the production of these products. So yes, our consumer choices can lead to injuries downstream, and the workers that bring us the product, but also the communities in which those workers live, and that's something we need to be mindful of. Well, the impacts can go even farther, especially when you have a situation where you have a very popular product that comes from maybe one or two particular regions of the world. And then in that case, what happens is the demand for a product can actually go beyond just a community. It can actually cause entire countries and regions to develop unstable and unbalanced economies that when things go wrong, these places can descend into civil war and chaos, and all sorts of other negative externalities can happen, and very widespread injuries, just as a result of being the place that's known for this particular product. And with that, we're going to talk about bananas, because bananas are an example of a product that, if it's done wrong can lead to grievous downstream injuries, and has actually in the past done that. Bananas are very popular here in the US. An average American will consume about 27 pounds of bananas per year. They're also very nutritious. They're a great source of B vitamins and vitamin C, potassium, and other micronutrients. Now, because of climate factors, for the most part, we don't really grow them here in the US. There's very limited production in some of the warmer weather states and territories, such as Hawaii, Florida, Louisiana, Puerto Rico, Guam, and American Samoa. But well over 99% of all bananas purchased and consumed in the United States are imported. And unfortunately, bananas are an example of how meeting a consumer demand has led to great injury, suffering, and injustice. And bananas are definitely one of those products where doing some traceability and looking at the supply chain, making your choices accordingly, can make a really big difference. So now I'm going to talk about some of the bloody and tragic labor history of bananas grown in several regions of Central America. First, I have to talk about the term banana republic. Now, this is an insulting term um, has been in use for several decades now. And when we talk about banana republics, what we're talking about are essentially countries whose governments have failed their citizens, whose governments are unable to provide basic services or stability to their citizens, and places where instability and corruption are rife. So, and unfortunately, being a place where bananas can grow is one of the things that often results in the failure of an official government. And so what we see with banana republics is we've seen it in many different countries and regions of the world, but first is the discovery that a particular crop grows well in the region, such as bananas or coffee or cacao, and that this crop that grows well has a high demand in developed countries. So seeing this, what happens is that large transnational companies that want to make money, they start buying up large swaths of land in these countries and regions where bananas will grow, and they become the major landholders. And these transnational companies start doing things that normally a government would do. They start building roads and railroads and ports and things like telephone and telegraph systems back in the era when wired communication was still more of a thing. So then what happens in these countries, and this happened in several different Central American and Northern South American countries, is that the economy of these countries becomes very heavily reliant on a single export crop, which means that the country can become very destabilized when there's fluctuations in the price of that single export crop. You don't have a diversified economy anymore. And then these large transnational companies that buy up all the land and build all the infrastructure, they basically become the de facto government these of these countries. The official governments become ineffective, or worse yet, they form oligarchies with the dominant business elites to ensure the that the interests of the business elites and the large transnational companies are met, even to the exclusion of the needs of their citizens. Another term that's often used for this type of government is kleptocracy. When you have a banana republic, you tend to have a large impoverished working class who is being failed by their government and whose needs are not being met by the transnational companies. And the nation is often run like a business that exploits its people and land for profit, often with collusion between government and business, as we talked about before. And you wind up with the public lands, the lands that should be used for the benefit of the citizens of the country, instead are exploited for the private profit of a few people. And then the ecological service depletion occurs, which harms the impoverished working class. Bananas in particular are very resource intensive. They require a lot of nutrients. They, they tend to drain the soil relatively quickly. They require a lot of water and pesticides. And you know, the same sort of thing that we talked about with the We Buy Who Pays film, where coconut and those subsistence farmers in southern India couldn't make a living anymore because of the pollution and depletion happening all around them with the dominant you know, dye and cotton manufacturing. The same thing happens with banana farming, where the ecological services get depleted and destroyed so that people that aren't necessarily working in bananas are negatively impacted. Guatemala is a vivid and tragic example of some of these forces at play here in the Northern Hemisphere. At the beginning of the 20th century, around the year 1900, people in the US and Canada really started to like bananas, and they wanted to. There was a big demand to grow as many bananas as possible for these relatively wealthy markets in the U.S. and Canada. And it was discovered that Guatemala had a really good climate for growing bananas. So, starting around the year 1900, some of the major transnational companies started buying up much of the land in Guatemala. United Fruit, the parent company of Dole, bought so much land in Guatemala that by the year 1950, United Fruit owned 70% of the entire land of Guatemala. They also controlled the only Atlantic port in Guatemala, Puerto Barrios. There's only a very small Atlantic coastline in Guatemala. There's a much larger Pacific coastline because the Atlantic coast is sort of squeezed between Belize and Honduras, and United Fruit controlled the only Atlantic port in all of Guatemala by the year 1954. But then, a few years before that, in 1951, the citizens of Guatemala went to the polls and they elected a new president, Jacobo Arbenz. And Arbenz had run on a reform-minded platform. He wanted Guatemala to work for Guatemalans again, not just to be a subsidiary of United Fruit or Standard Fruit or any of the other major banana companies around the world. So at the time that Arbenz was elected, United Fruit, even though they owned 70% of all of Guatemalan land, were paying virtually no taxes. Again, this was based on an agreement signed with the previous leader where there was a declaration that this land didn't have very much value, therefore United Fruit was paying virtually no taxes on it. Well, some of those reforms that Arbenz brought in when he was elected really made an enemy of United Fruit. First of all, he and his Congress granted all citizens of Guatemala the right to strike, an important piece of labor reform. The new government also went on an ambitious land reform regime where they started buying it back from United Fruit. And what they did was they bought 400,000 acres of land that United Fruit owned, but they were not actually using at the time. It was in that fallow period where you have to take land out of production for several years at a time so that nutrients can cycle and so that the land can become productive again. Because, again, bananas are very ecological resource intensive. What Arbenz did was he only offered the selling price for this land. He only offered what the tax value of it was, which was virtually nothing because United Fruit and the previous government had agreed the land was only worth a very small amount of money. And so the plan was to buy this land back and return it to the citizens of Guatemala, and that's what he did. But this made United Fruit very angry, as you would imagine. United Fruit, or Dole, was a U.S.-owned company, and they were very unhappy with Arbenz and his labor and land reforms that he was trying to do. So United Fruit actually appealed to the United States government in an attempt to discredit the new Guatemalan government. And the campaign to discredit the government was very successful. They started a whisper campaign to the State Department that this new government and that was communist and that Arbenz was a communist. And in fact, the State Department bought United Fruit's messaging. And as a result of this messaging, yeah, Arbenz was officially labeled as a communist, which this was in the middle of the 20th century during the sort of the peak of the Cold War in retrospect, a really tragic, but also a really silly time when, just being thought of as a communist was the worst thing imaginable for if you were an official in the U.S. or in any way supporting communism or collectivism. And it seems just ridiculous now to imagine that a labor-minded and reform-minded government in Guatemala could somehow threaten not only United Fruit, but the greater idea of capitalism. And it seems silly now, but in the mid 20th century, this argument won the day, and United States Navy actually started a blockade of all the ports in Guatemala to try to sort of caused the government to destabilize and to become overthrown. There was not very much direct tactical support you know, given to people in Guatemala fighting against the Arbenz government, but there was just enough to actually cause the government to fall. And think about it, how troubling is this, that an elected government in another sovereign nation was overthrown because a U.S.-owned company petitioned the U.S. government to do something, and they did. They labeled the new government as communist and encouraged the overthrow of it. And then after Arbenz was overthrown, a new U.S.-backed pro-business and authoritarian government was installed that, of course, capitulated to all the interests of United Fruit and all the other major banana manufacturers that were in Guatemala at the time. Well, the citizens of Guatemala, they didn't like the fact that this puppet regime was installed, and so for the next 3.5 decades, there were various times when insurgencies occurred and on and off again civil war that left a total of more than 200,000 people dead and many more injured. So again, bananas are a vivid example of how a consumer choice led to downstream injuries that were just unthinkable. And this was an era when supply chain transparency wasn't really a thing, when people just didn't really think as much. There was a demand for bananas, and it was thought that anything that meets the demand for bananas must be ethical or must be okay. I mean, thankfully, we know better than this now. I mean, I'm not saying that modern banana farming isn't somewhat exploitative, but it's not to the degree that it used to be in the early and mid 20th century, when it was actually leading to entire governments collapsing and hundreds of thousands of people dying in civil conflicts. The history of bananas in the 20th century also includes a chapter involving chemical exposures leading to severe injuries. And for that, we turn to dibromochloropropanone, or DBCP. This was a pesticide developed in the United States in the mid-20th century, specifically in 1955. It was a pesticide used as a soil fumigant against nematodes, which, if these nematodes were left unkilled, they would attack the roots in pineapple and banana crops and possibly lead to catastrophic failure of the crops. So it was invented in the United States in 1955 and then went to market and was sold by 3 different companies, Dow, OxyChem, and Shell. Now, even though it went into the market in 1955, the toxicological data for this product was really not available yet. They started collecting it the same year that it went on the market. And between 1955 and 1961, there was a lot of toxicological data on DBCP gathered with rats. What was shown was that male rats had testicular atrophy and anti-spermatogenic effects. In other words, they were not able to produce sperm. And it was found that both male and female rats exposed to DBCP were exhibiting signs of kidney damage. If you remember your toxicology and the teachings of Paracelsus, you'll remember that virtually everything can be a poison, and it's the dose that matters. But with the DBCP studies, these rats were not being exposed to outlandish exposures that were well beyond what a person would be exposed to. They actually tried to replicate exposure patterns that would occur to workers, banana field workers. And so these rats were only exposed to DBCP for 7 hours a day, 5 days a week over the course of 10 weeks. And during those 10 weeks that they were exposed to different exposure levels. It was found that you started to see clinical effects around 5 parts per million of exposure. Didn't really see too many below that. But at 5 parts per million, the male rats had an 18.6% decrease in the mean weight of their testes. This was not statistically significant, but it was certainly clinically significant. An almost 20% smaller testes will produce fewer sperm than a normal-sized one. It was found that rats exposed to 10 parts per million with this exposure pattern over 10 weeks had a statistically significant decrease in mean testes weight for male rats, almost a 49% decrease, and for both female and male rats, a 31.7% increase in kidney weight. Whenever you have a toxicant that's bound up and where glomerular filtration is relied on to try to get rid of it, this is often manifested in enlarged kidneys, and these filtered products can accumulate in the kidneys and cause local inflammation and problems, and that's why increasing kidney weight is often a pretty severe harbinger of kidney disease. It was also found that at 20 parts per million, all male rats became sterile. In other words, they produced zero sperm. So these toxicological findings were collected between 1955 and 1961, and they were published in 1961. There were probably many researchers back in 1961 after the toxicological data had been published that were probably not really happy about the idea of DBCP being approved by the Food and Drug Administration as a pesticide. But there were also the interests of the banana growers to consider, because they had started using DBCP, and their banana crop yield had gone up to a degree that had never seen before. By killing these nematodes, they were producing more bananas per acre, and they were making so much more money than it ever made. So there was a lot of pressure from United Fruit, Standard Fruit, Chiquita, all these other banana companies on the FDA to approve this pesticide for use. And there was probably a few researchers that were pushing back and saying, no, it's unsafe. The toxicological studies show that it causes, sterility, or at least infertility and smaller testes in male rats. Ultimately, the compromise that was struck was that the Food and Drug Administration decided that, yes, we will register and approve DBCP as an approved pesticide to use on a food crop, but we will apply a workplace exposure limit where nobody is supposed to be exposed to greater than 1 part per million of it as an 8-hour time-weighted average. And keep in mind, this was in 1961. This was 9 years before OSHA even existed. So this was still the era when, if you were going to have a workplace exposure limit for a chemical, it had to be done piecemeal by other organizations such as the FDA. And again, keep in mind that this seemed to be at least somewhat conservative or protective, because the lowest toxicity level seen in rats was 5 parts per million. That was the first level at which the shrinking of testes was observed. So it's believed that if you had a level that was 5 times less than that, that would be a conservative and protective level for workers. So registration and approval was granted by the FDA in 1961. And then the U.S. Department of Agriculture, who of course has a lot of the regulations that have to do with food crops and things like that, they started approving product labeling for DBCP, that went out to the banana fields in Central and South America. This product labels, though, did not mention anything about possible reproductive effects. So what happened was this product, DBCP, was manufactured and used for more than 16 years in banana fields before the first human health effects were noted. So for 16 years, from 1961 to 1977, the working assumption that everyone had was that whether you worked in a production facility that made DBCP, or if you used DBCP as an end user, like in a banana field, that as long as you kept your exposure below 1 part per million as an 8-hour time-weighted average, that everything was fine. There shouldn't be any toxicity issues. Well, in 1977, something happened which kind of made people realize that maybe we had a real problem. The OxyChem plant in Lathrop, California, just outside of Stockton, was one of the plants that made DBCP. The workers at this OxyChem plant started reporting infertility concerns to their supervisor, like they were wanting to start families and they were finding themselves unable to. So a request by OxyChem was put into the National Institute for Occupational Safety and Health, the occupational safety and health research arm of the CDC, and they did a full-fledged health hazard evaluation in this OxyChem plant. What they found was that of 13 production area workers that directly worked with DBCP in the manufacture of it, 9 of those 13 workers, they were all male workers, 9 of the 13 were fully sterile. In other words, they could not produce any sperm at all. The other 4 workers had profoundly reduced sperm counts. And the reason why this was so troubling is that this plant had been monitored for years. They'd monitored airborne DBCP to make sure that levels never exceeded 1 part per million. They had industrial hygiene data showing that airborne concentrations were always far below 1 part per million, even in all the manufacturing areas. There was a belief that maybe dermal exposures might have been another way that workers were being exposed, but regardless, What was clear was that the current standard, which had been adopted by the FDA in 1961 and then had been adopted by OSHA when it was established in 1971, and it had been incorporated by reference as the DBCP standard, was clearly not good enough. So what OSHA did was issue an emergency temporary standard, which was 1 part per billion as an 8-hour time-weighted average. In other words, the DBCP maximum allowable concentration in workplace air was reduced to 1/1000th of the level that it used to be. This emergency temporary standard was finalized in March of 1978. So from that point on, no workers who produced DBCP in the US were permitted to be exposed to more than 1 part per billion as an 8-hour time-weighted average. You can probably guess where this story is going. If you're asking yourself the question, okay, were these protections that were made available to US workers who produced this chemical, were those same protections going to be given to the field workers in other countries who were working with this chemical? Yeah, you can guess that the answer to that would be no. Way back in 1969, DBCP was being widely used on banana fields in Costa Rica, Honduras, and Nicaragua because, again, throughout the 1960s, it was improving yield and making bananas grow, greater than they'd ever grown before. During this whole period, the export labels for the DBCP did not warn of possible reproductive effects, and furthermore, they were all written in English. They were not translated into Spanish so that workers could actually understand what these export labels said. Back in the US, in September of 1977, around the same time that the occupational incidents in Lathrop, California were starting to get noticed, the US EPA announced that DBCP domestic distribution, in other words, use in the United States, would be suspended under the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA. There was a very limited use that was allowed to continue in Hawaii for certain specific pineapple areas until 1985. But for the most part, when this domestic distribution suspension occurred in 1977, and then later on it was actually turned into a permanent ban on DBCP as an agricultural pesticide. It would no longer be used on the very limited US banana crops or most of the pineapple crops either, with the exception of a few plantations in Hawaii, which were given authorization to keep using it until 1985. So no more use of it in the US. But again, I think you know where this is going. So in the year 1979, US usage of DBCP was essentially banned. And of course, it did not stop the manufacture of DBCP. It could still be manufactured in the US, provided that no workers were exposed to levels of greater than 1 part per billion as an 8-hour time-weighted average. But Standard Fruit, the parent company of Dole, and many other companies continued to petition for DBCP to be used on banana fields because it was considered essential, and it was still believed that the toxicity risks were minor. The belief was that end users of it, who are out in open banana fields and on the outdoors, are not going to be exposed to the same degree that the manufacturers inside the plant in Lathrop, California were getting exposed to it. Again, that was a very disingenuous argument, and it was based more on they wanted to keep using it in the other countries and because it was good for their profits. What's interesting about that time is one of the 3 companies that manufactured DBCP, Dow Chemical, some of their board of directors actually started to get a little bit of a conscience and started to be reluctant to sell DBCP to, in this case, Standard Fruit, who they were contracted to provide it for. Well, Standard Fruit actually threatened to sue Dow for breach of contract if they would not sell DBCP to Standard Fruit anymore for them to then use in their Central and Northern South American banana fields. There was a settlement reached where Standard Fruit agreed to indemnify Dow for any injuries that resulted from DBCP exposures. And unfortunately, and tragically and predictably, again, what happened was that DBCP was used in Central American banana fields and plantations until at least 1985 and continued to be used in the Philippines until at least 1986. I mean, 6 and 7 years after it had been prohibited from being used in the US at all, and after the workplace levels had been reduced to just tiny infinitesimal amounts, but it was still openly used in Central America banana fields. So as you can imagine, the negative publicity generated about DBCP, due to the workers in Lathrop, California, and the banning of it for agricultural use in the U.S., eventually field workers in countries where bananas were primarily grown started to realize that, oh, they had been having some fertility problems as well. And in fact, many farmers and pesticide handlers in Guatemala and Honduras and Mexico and many other countries started to realize that their problems conceiving were due to this DBCP that they were being exposed to, that the banana companies and the pesticide companies had completely failed to protect them from. Because these companies were based in the United States, Dole, Chiquita, Del Monte, the banana companies, plus the chemical companies, Shell, Dow, and Oxy, the workers, even though they were not U.S. citizens, actually had standing to sue these companies in U.S. courts because they were U.S. companies that had done something that inflicted injuries to these workers. So there were numerous court cases brought against all of these companies from 1990, and they continue to the present day, by field workers who became infertile or even sterile from their exposures to DBCP. And some of them have received settlements that have brought varying levels of justice. I mean, the settlement money can never bring back their ability to father children, which was lost, but there have been varying levels of justice brought. But again, you're relying on tort lawsuits and being given standing, to non-citizens of the U.S. to sue U.S. companies. So it's not a perfect system by any means, and a lot of injuries occurred that never should have happened in the first place. What's also tragic is that decades after its last usage here in the U.S. and in Guatemala and other places, the ecological effects of DBCP lives on. In the Sacramento Valley of California, DBCP is a persistent organic pollutant. It still exists in some of the aquifers, and there's still some areas where the Safe Drinking Water Act maximum contaminant levels of DBCP are being exceeded by some of the local drinking water. So yeah, the story of DBCP and bananas is a tragic and unfortunate and actually kind of infuriating one if you think about it. I've talked a lot about bananas, and in doing so, I didn't do that with the intention of making you feel bad about enjoying bananas. There's nothing wrong with enjoying bananas. They are a very tasty and nutritious food product. But bananas are also illustrative of how, if we don't think about supply chains and traceability and how a product gets to us, if we just sort of let market forces dictate that without any attempt to, introduce ethics or things like that, that they can be very exploitative. A lot of people can get injured and killed, and communities can be devastated, and lots of things can happen based on our consumer choices. So yeah, our consumer choices can have quite an impact downstream on people. So what can we do about this? Well, the one thing I want you all to do, just always remember this: supply chains. That's a very sort of clinical and analytical and somewhat impersonal term, but always remember that supply chains, those are actual people embedded within communities and also within ecosystems. So when we think about how our shirts get to us, or our snack foods, or anything else like that, we need to be, if we're wanting to be thoughtful, ethical, public health minded people, we need to ask at least the one basic question: would we be willing to endure the same risks from workplace or ecological injuries that we are asking other people to endure for us to bring this product or service to us? The other thing we need to remember is that in the age of the internet, traceability has increased greatly. We can now know, we can trace supply chains better than we've ever been able to do in human history. And really, any buying choices we make are votes for what kind of future we believe in and what kind of world we think is right. Now, before I go any further, I want to make one thing clear. We have time limitations and budget limitations and brain space limitations. I do not expect any of you all, because I don't do this myself, we cannot research every single buying choice we make. Again, we have time and budget and cognitive limitations on that. What we can do is just try to do a little bit better. And the challenge that I want to give you all here as we get near the end of this lecture, it's something that I do, and it's something that I find to be very meaningful and gives me hope, and I want you to feel that way too. So I want you to think about one product that's very important to you. Maybe something you use every day or every week, but something that is meaningful or useful to you, just a key product in your life. And what I want you to do is at some point do your own traceability research on that product. Try to find out which company can provide that product to you in a manner that most matches up with your values and your ethics. That results in the least amount of exploitation or ecological service depletion or injuries. And make sure that you acquire that product from the company whose values most closely reflect yours. I mean, it's a very meaningful thing that you can do, and you will feel better if you do it. Another thing we can do is we can demand better from the most egregious violators, from the companies who most exploit, most violate human rights, who maybe have done things to destabilize governments and exploit people and usurp ecological resources. For the most egregious violators, we can choose not to support them, and we can tell people we know not to support them, and let these companies know that until they start doing better, because we can trace now and we know exactly what it takes to get these products to us, that we're not going to support them until they do better. I understand and respect the fact that the audience for this lecture are undergraduates who are taking PBH 275. Some of you are public health majors, some of you are not, but some of you are in a phase of life where you don't necessarily have a lot of discretionary income. For a lot of the most important products in your life, you're going to be price sensitive, and that's okay. That's understandable. But again, like I said before, take that challenge for one key product in your life to see if you can find a more ethical provider of it. And even if you have to pay a few more cents for that, it will help a lot, and it'll make you feel better about it. Another thing that we can do is, where budget and availability allows, consider fair trade certified products. If you're wondering what are fair trade certified products, well, it's it's a certification scheme, which I'll talk about a little bit more in the next slide. But what fair trade certified products kind of start with an acknowledgement that existing world trade practices promote unequal distributions of wealth, but also of risk. The wealth tends to go upward to people in higher income countries at the top of the supply chain, whereas the risk is distributed amongst the workers and the communities in which the workers live. That's what existing world trade practices have done, and that we need to do better than that. So what fair trade advocates for is that you buy products from producers at a fair price, a price that enables the producers of that product to actually live with some dignity and to not have to work overtime or work in excessively dangerous conditions or literally work themselves to death. And that by doing so, that's a more efficient way of promoting anti-poverty and sustainable development, much more so than traditional charity and aid, even though traditional charity and aid does have value as well. Fair trade certified products provide dignity and respect for producers. They promote supply chain transparency, but fair trade certified products and the mechanisms for it are funded by higher market prices. You will pay more for fair trade certified coffee or cacao or clothing compared to products that are not certified. It's because a lot of the externalities are priced into it, and the end user or the consumer is paying those rather than the producers having to suffer all of those. So what are some of these principles of fair trade and fair trade certified products? I'm not going to read all of them, and they sometimes vary from organization to organization, but in general, there's usually about 10 to 12 core principles of fair trade that most certification bodies recognize, and I will just go over a few of the key ones. One of the most important ones is fair payment. This means that people are not impoverished, even at the very bottom sort of end of the supply chain, the people that are just making the raw materials, they're not the finished value-added product, that they receive a fair price for these materials so that they can they can live with dignity. They can actually reinvest some of their profits into their community and build communities that are better rather than communities that are kind of hollowed out and damaged and destroyed by a more exploitive type of trade mechanism, like we saw in the We Buy Who Pays film. That traceability and transparency, and just the supply chain is so much more visible and in a fair trade certified product, whereas in non-certified products sometimes because they realize it will be bad publicity, there are certain elements that the companies will try to keep from being discovered. No forced labor and no child labor or other fair trade certified product requirements. And it goes beyond just prohibiting forced labor and child labor to actually dealing with the mechanisms that sort of drive companies toward considering forced labor and child labor, just making sure that there is no exploitative and no that there's adequate educational infrastructure in these areas where fair trade certified products are created, so that there's no pressure for children to drop out of school and go work at the factory to support their families. I mean, and certainly no forced labor either. Respect for the environment is another key one, where fair trade certified products, I mean, part of the reason why they cost more, why you pay a little bit more of a premium for fair trade cacao and clothing and coffee and things like that, is because they use sustainable techniques that it might cost a little bit more for inputs, but then you wind up without having so much ecological depletion and so much damage, where you wind up with destroyed communities and destroyed ecosystems. I mean, these are more sustainably done. And then just creating opportunities for disadvantaged producers. Anyways, you get the idea. You can pause and look at these if you want, but these are very key and good things. And yeah, you might not be able to afford fair trade certified products at this stage in your life, and some of the products that you need and use, there might not be a fair trade certified version of it, and that's okay. But again, as our time and budget allows, and as the market, as products come onto the market, we should try to integrate more fair trade certified products into our life as we can. So in closing summary for this module, going back to the beginning of this module, we were actually talking about the role of law in injury prevention. I know that seems like it was several minutes ago now, but just a quick reminder of that legislation, administrative law, court cases, and tort settlements have provided significant but uneven levels of injury prevention in the U.S., but they've still played a very important role. And many lives have been saved because of the role of laws in the U.S. here. And then for the other part of the lecture, the labor practices that drive our consumer choices can be a major source of individual and community injury in other nations and cultures, and even within our own nation, if we're talking about products that are created by, that are grown and picked by people who are maybe undocumented, for example, and don't have labor protections that documented workers would have. I mean, that's an exploitive condition that makes people more vulnerable to injury. So we need to think about the labor practices that go into our consumer products. And always remember, supply chains, these are actual people embedded within communities and ecosystems. Let us never lose sight of that. That's it for this week. Let me know if you have any questions, comments, or concerns. Thank you for your attention today.